honored to be on the stage with Jonathan, but also in the room with all of you. I would just say, by a brief footnote, one of the things that I teach at Georgetown, one of the classes I teach at the law school, is challenges to liberal democracies. And so much of the writing and the analysis is about accumulation of power in government, and not enough of it connects accumulation of power in the private sector, but actually what is most significant in many ways is the connection between those two. And it's really exciting to be part of a conversation that recognizes the role of political economy as a constitutional issue. So I'm going to start by asking you, Jonathan, a kind of a very broad opening question, because I know you kind of grew up in antitrust and competition policy, but there's really been a kind of a transformation. You're part of it, but did you come in that way? What happened? Did you have an epiphany? How did you come to a new appreciation of the fact that we needed to change the direction of our enforcement?
Well, first of all, thank you for having me. It's just truly an honor to be with you and to see all of you out here today. This is a fascinating conversation, and I'm just delighted to be a part of it. So for me, it's been a journey, and I've one where I've tried to be honest with myself throughout. And so when you have the opportunity to practice an area of law, you have the opportunity to see up close what works and what doesn't, and perhaps what's missing and what's not. And so I struggled to identify an epiphany or a single moment in time when some of these issues came into focus. But instead, to me, it's been gradual. But I think it's the linchpin for me has been honesty. Honesty with myself in terms of what I'm seeing. Honesty in terms of identifying what works and what doesn't. And at the same time, thinking about the work that we do in antitrust law against the backdrop of what it means for our society. And I think sometimes that gets lost. And I can understand why. In law enforcement, we're often thinking about one case at a time, and that's the right way to enforce the law. You have to look at the facts, you have to look at the law, and you have to make reasoned, sound decisions. But all of that is against a very important backdrop of policy, backdrop of impact on our society, and as we'll talk about today, impact on our democracy. And I think when you're in the weeds, it's sometimes very difficult to lose sight of that. But I think it's very important, especially for people who practice antitrust law, to constantly revisit the reason for the antitrust law's existence in the first place, and make sure that we are enforcing the law in a manner that is consistent with the objectives of the antitrust laws and a democratic, free, open society.
Well, so, since we're on the topic of democracy, I spent the last few days reading all of Jonathan's speeches for the last year or so, which are fabulous. You can find them all on the Justice Department website. But they're really terrific. But I was particularly, partly because I'm a partisan, right, drawn to a speech that you gave at Georgetown that really, I thought, just gave a nice encapsulation of this theme, where you said competition enforcement does not merely drive progress and prosperity for consumers, workers, and others in our economy. Competition enforcement supports economic liberty and protects our democracy. You go on to quote President Franklin Delano Roosevelt, who said, "Freedom is no half and half affair." He spoke about how equal opportunity in the polling place and the marketplace go hand in hand. So I was so taken with your framing, and I was wondering if you could speak a little more to how you see the anti-monopoly fight and competition policy as being so central to democracy.
Yeah, so it's across many different dimensions. Let me take a step back and just give you a sense of how I see the world going back to when I was a child. I grew up in a solidly middle-class apartment in Queens, New York, and in a solidly middle-class neighborhood. My parents were school teachers, and it was a loving home. To me, the American dream was about being able to make decisions and chart your own path. So the American dream to me was owning your own home, your house. The American dream was being able to start your own business, do something you love. The American dream was being able to determine success or failure based on the merits of your talent, your achievements, and your choices. And to me, that's about opportunity. And so to me, the American dream falls apart when you no longer have opportunity. And that opportunity is both, flows from our economy. It flows from where you want to live, where you want to work, what do you want to do with your life, how do you want to provide for yourself and your family. Like, these are core existential issues for our people. And to me, when I think about antitrust enforcement, when I think about competition policy and concentration of power, I think about anything that threatens our ability to have those opportunities, to make those decisions, to have self-determination, and that's threatening. And so whether that comes in the form of concentrated economic power that takes away those opportunities, or concentrated power that has undue influence over our political system, it's all relevant.
So you have been, you've really taken forward some really important cases while you've been head of the Antitrust Division. And in particular, sort of taking on the consolidation of the publishing industry. In that case, you made, it seems like, a big departure from the consumer welfare standard. Why was that case so important for our democracy?
So that was an important case on a number of different levels. I guess I'll start by saying, to me, the most important level is the fact that it involved books and ideas, journalism, and investigative reporting, right? These are the arteries of our democracy, right? Like, it's at the foundation of who we are and how we learn and how we grow and how we're informed and how we exercise our freedom in daily lives based on information. And to me, it wasn't just about a number in terms of the advance that an author might get. It was the money that an author relies on to research a book thoroughly, to explain concepts, scientific concepts, political concepts, even to entertain, but to do so in a way that stretches the imagination and educates a society. If we're not fighting for that, then what should we fight for? And so, to me, that goes at the very heart of our democracy. It goes at the very heart of our free flow of information in an open society. And so, it's important for a lot of reasons. It's also important because we were focused on monopsony power, which is an extremely important element of how we think about competition for labor and opportunity. But for me, that case starts with the importance of the product, which is not just a price; it's our very freedom.
Well, so as you were talking, I was thinking about Google Books, because Google's obviously, it's been on everybody's mind. It's just sort of, it's incredible when you have a corporation that has become a verb, right? It means something to us that we now have this corporation that is so dominant that it's a verb. There are a few other corporations like that, but they don't have nearly the footprint that Google has, right? I was just listening to a podcast about AI, and they're talking about Bing and Microsoft, but they're using, talking about Googling things. And so Google is, I think, the big case that everybody wants to hear you talk about. You're again departing from the consumer welfare standard. But it's really interesting because for people who are perhaps less immersed than this audience in kind of competition issues and anti-monopoly, they go, Google's actually, it's the best search engine. So why isn't that okay? So what are you trying to do here, and why is this so important?
Yeah, so for reasons hopefully you'll appreciate, I can't talk about matters that are in active litigation. So I'm going to take a step back and talk about things at a higher altitude. But so for me, antitrust is about competition, right? The authors of the Sherman Act and the Clayton Act and various other competition statutes made a decision that the competitive process, the process of rivalry, is critical to generating the kind of opportunity that makes us all better. And that makes us better in terms of innovation. It makes us better in terms of lower prices and more access to information and data, more choice. I mean, you can go on about the benefits. And I think what we want to encourage more. We want to encourage more opportunity, more innovation, more access. And the foundation of the antitrust laws is that more competition is better. And that if companies are engaging in conduct that restricts the competitive process and allows them to entrench their monopoly power, that is against the plain language of the statute and therefore may necessitate law enforcement.
Well, you talked about monopsony, and I'm really interested in the work that you've done in the agriculture industry and in food generally. And I know that for open markets, that's been a big focus and it's extremely important. And again, I don't know if you can talk about this, but I was just reading, and many of you probably did as well, about the case against John Deere. I just, it's just phenomenal how much control these companies have over farmers and consumers. But can you speak generally, even if you can't speak about that case, about the work that you've done to try and demonopolize the food industry and the agricultural industry?
Sure. So I will let our brief speak for itself, but you'll find online a brief that we filed this week in connection with an antitrust action against John Deere that talks about the ability of farmers to actually use the equipment that they've purchased with their hard-earned money. But we have an extensive program around agriculture. We've brought cases that address the tournament system for growers. We've brought matters that affect and have secured over $100 million in criminal fines relating to various different proteins and price fixing, and we've addressed information sharing and wage fixing. There's a lot to do in this space. It's an extremely important space. Some of the most meaningful meetings that I've had since taking this position have been sitting down with farmers. Like when you think about, again, the American dream, you think about a farmer working the land, building. These are not just farmers; they're business people, but they're business people who are giving us, the ability to have a thriving economy, to eat, to affect our food supply, and hearing some of the challenges that they confront is often gut wrenching. And so I think it is really important that we pay very careful attention to these issues and that we are enforcing the law. Again, we always follow the facts in the law wherever it takes us, but we are sufficiently attuned to issues that affect agriculture and our farmers and our growers.
Mm-hmm. You should find it online. You can read the brief, but also read the news stories there. It's the inability to repair these tractors that is the question. And I think, most of us probably don't own a tractor. Well, maybe you do. I don't know. But we probably own some other device that we think we should be able to get repaired. But the companies are making it awfully hard for us or preventing us from doing so. So I think these stories can really resonate across different areas. Can you talk generally about, how do we broaden our discussion? I mean, I think the Taylor Swift, Ticketmaster story should be one that should enable the anti-monopoly movement to kind of connect to a broad audience. Can you speak to sort of the narratives that you might employ and how we can kind of talk about these issues with a broad audience?
Yeah. So when I first started, advocating for enforcement, it was often a very difficult conversation because it would become technical. It seemed like antitrust was something that was not accessible to the public. And there wasn't the sort of public awareness and consciousness of concentration of power. It's amazing, right? I mean, I'm looking out at this room and seeing, it's packed from, top to bottom. People are standing in the back. This is everywhere. People are talking about it, and it's not just people who are in my field who are lawyers. They're students. And there's some students here today. I've been traveling around to law schools around the country, and people are coming out in packed rooms to talk about antitrust. It's in our newspapers. It's in our online discussions. It's discussed at the kitchen table. And the reason I believe that that's people understand it is because they see how monopolies affect their daily lives. And I think the issue of monopoly power is something that resonates because, and I'm sure all of you in the room can think about issues where you've been frustrated, angered, let down, exploited by a monopoly somewhere. And those instances are increasing in frequency, and the touch points for that monopoly power are becoming, frankly, too frequent and too broad. And so for me, it's really about letting people understand or letting them express how this reflects and affects, rather, their daily lives. And that's different than the very technocratic discussion that took place when I started practicing. And I think boiling it down to how it impacts real people is essential to having an honest conversation about where we go from a policy perspective.
Well, I have to say it's true in the legal academy. I see this transformation with the students. I mean, there's much more seemingly attuned into issues about private power, of the aggregation of wealth and power, and how it actually, the intersection with political power, and understanding that monopoly and competition policy is a central piece of this.
Yeah, I will also say that great ideas, creativity, thought leadership is being generated out of law schools, out of universities, students who are coming at this fresh with a degree of common sense that perhaps was missing from how we thought about these issues over the last 30 years. And to me, that's animated this area and made it more effective and more powerful. And I always discuss how my job is to keep the chair warm until they take over, because I am very optimistic about the future. As I go to these law schools and I talk to students, I'm not hearing, I'm hearing amazing ideas. I'm hearing deep passion about these issues. I'm hearing a desire to help fix a problem that they identify. And again, I find that very motivating and inspiring. And I know there are a lot of great things to come in this area. We can keep it safe until they take over.
I don't think anybody here thinks you're a seat warmer, Jonathan. That would really not do you service. And I would say, so Jonathan, has followed in a very illustrious line, including who's Assistant Attorney General in charge of the Antitrust Division, including Thurgood Marshall. So I mean, it's a hardly a seat warming kind of a position. But speaking of legal academy, what do you think our role is? Because, and I know we have a few others in the room, including Joey Fishkin, who's going to come up next, who will talk about his incredible book. But so what should we be doing? What should law schools be teaching? Have they transformed enough in your mind?
That's a very general question in terms of law schools. I think it'll vary, but I think there's an important role for the academy to play, an essential role for the academy to play. As we educate our next generation of lawyers and law enforcers, is explaining, sort of as you're doing today, how we think about antitrust law and antitrust enforcement in connection with the other values that are foundational to our society and our democracy. And so I think, for a long time, last 15, 20 years, antitrust was taught as a very technical, at least in many law schools, as a very technical course, almost like an econ course. But I think understanding why we have antitrust law enforcement to begin with, why it's so important, what the consequences are of monopoly power, what the ideals that were embedded in the antitrust statutes that we enforce, why they exist and why they were written in the first place. I think that foundational knowledge is extremely important to understanding how we determine our competition policy as a country and how we determine, the best way to appropriately enforce the antitrust law and advocate before courts.
So it just, not that I'm going to talk about all my classes, although I'm sure you all want to take them, but I also teach a class on legislation and statutory interpretation, and one of the segments is about lobbying and corruption and campaign finance laws. And I tried, the students are pretty sophisticated, obviously, but part of this is, as we talk about political economy and constitutional political economy, it is about the fact that our economic system is a structured one and structured by politics, and in part it's structured by large monopolistic corporations that play in all these realms, right? Who's been spending money on Capitol Hill? How is the lobbying budget for Google, for example, grown in the last several years? I was chief of staff to a senator, Maria Cantwell from Washington State, after the lawsuit the DOJ brought against Microsoft. And Microsoft, their whole orientation towards Washington was very different, but you see sort of that role in sort of trying to preserve a certain kind of view of what the economic structure could be. But so how do you see the kind of political economy? How does our constitutional structure play into creating the economy that we want?
We need a government, for the people, by the people. And if there's no voice for the needs of, our entire population, then, we risk the process only benefiting a small few. And, if someone believes that concentration of power gives companies greater political influence, and I think there's a lot of research to suggest that's true, then we should be very concerned.
It's political influence, and it's also bargaining for contracts. It's like being a provider, a contractor to the government, and it's also lobbying the government. The tentacles are really far-reaching.
But let me also, say this, because I know there are a lot of people, and I see many of them in this room, who care deeply about these issues and who speak up. It matters, right? You can fight back. You can advocate for what you believe in, what's important to you. And if people won't listen, speak louder.
Mm-hmm. What else should we be doing, Jonathan, in your mind? How can we out here be supporting you, and how can we help build the anti-monopoly movement?
Well, I think, again, our work is on law enforcement, and we look at each case on the merits of its facts and the law, and we follow that wherever it takes us. I think when we think about competition policy more broadly, it's important to make sure that all points of view are being expressed to members of Congress and to decision makers. And so if people believe that monopoly negatively affects their lives, saying so and explaining why is a very powerful thing.
So I want to ask one more question, and then I know we have a little bit of time for questions from the audience. But so, you have talked while you have been at DOJ about the importance of applying non-discrimination rules, such as those found in common carrier law, to regulate the power of corporations that provide essential services or goods. So can you talk a little bit about that? And why is that important? And what does that mean?
Yeah. So one of the themes I like to emphasize are conflicts of interest. And so where we often see antitrust problems are when we see conflicts of interest. For example, if you own the platform and you compete on the platform, it can create a conflict of interest, and it could lead to the kind of conduct that excludes and that is designed or discriminates in order to exclude. So it might discriminate against rivals or in order to exclude those rivals. And so that's increasingly common, unfortunately, in a world where intermediaries are becoming present in almost every market. And so it's really important from my perspective that we have a deep understanding of how these markets function, a deep understanding of how companies can act on those conflicts of interest, and a deep understanding of how we build an antitrust enforcement regime that is relevant to current market realities. And I think as we have seen over the last 20, 30 years, those market realities have shifted dramatically. Again, in terms of the growth of platforms and intermediaries and decisions that are being made at the intermediary level instead of at the individual level. And so those are all really important factors that I think have changed and evolved in our economy and as a result necessitate some degree rethinking how we approach our enforcement.
Right. Well, thank you. I think we're down to not a huge amount of time. So I wanted to see, and Anita has a microphone in the back. So if anybody has a question, otherwise I know that there are also people online who might be have questions. Otherwise, I'm going to monopolize Jonathan. So now's your chance.
Be careful. I might enforce.
Oh, yes. Question up front. Slip of the tongue up here. Oh, and we have another question up here, too.
Thank you very much for speaking to all of these issues. I noticed today has a very distinct theme, and that theme is about monopoly, your Sherman Act Section 2. But Sherman Act Section 1, of course, talks about some of the things that you might have spoken to, intermediaries and perhaps the duopolies, collusions, and things like that. Could you speak a little bit about that as well as how you see that landscape?
Yeah, so Section 1 is, foundational to our antitrust laws. Anti-competitive agreements are, at the heart of our enforcement agenda. And so we bring cases that, carry criminal liability, for example. And, one of the items that I've talked about frequently, particularly recently, is how agreements or information sharing or coordination can take place in ways that are fundamentally different than they were perhaps 30 years ago. And so an example I often like to talk about is, think about like the 1990s when people would share information, it would be most often in a manila envelope. And if you're, really cutting edge, you had this really sophisticated thing called a fax machine, and you'd send it. That's not how people share information today. Today, information is shared programmatically en masse, and it's not, intermediaries are not watching the information, but they're analyzing it and drawing additional insights from those from those data and from the data, and that's changed. And I think if we're going to be effective enforcers, we need to understand that if folks are going to enter into agreements or companies are entering into agreements through sophisticated information and data sharing, then we need to have an enforcement program that's attentive to those realities.
We had one more question up here. Do we have time for one more question?
We have about 2 minutes left.
Okay. We have right up front.
I'm Chris May with MLEX. I wanted to ask whether lawyers have a monopoly on the law. Richard Posner previously described the legal profession as a ingeniously reticulated cartel. So I wonder if you think that still applies today.
I'm going to defer to my fellow panelists here.
Oh, I'm a
law
professor.
professor.
Yeah, I mean, to some extent, it's self-regulating, and it has admission requirements that it helps determine and limit the number of practitioners, right? So to some extent, it's kind of balkanized though, because every state has their own bar and there are different bar exams and all of that. But it's not Google though, I don't think.
It's a fascinating question.
I'm saying Posner is always great for a quote.
Just if I could quickly follow up.
Hi, also from MLEX, Kushita. This question is probably going to make you uncomfortable, but I would really appreciate if
As long as it's for Jonathan.
you could set the record straight on that. There's been this chatter about the agencies sort of setting up these side deals and side consent decrees, and if you could please set the record straight on that.
Today's discussion is about the importance of antitrust enforcement in our democracy, and I really want to stay on topic. I'll just say that there's a lot of information out there and rumors, and I prefer if folks want to present facts or actual instances to respond to. I'd be delighted to do that.
Let's thank Jonathan for his great presentation.
Thank you so much.